In California, after a creditor wins a judgment against you, they can sit you down under oath and ask you about everything you own, every property you own, every LLC, every bank account. This process is called a judgment debtor examination, and the attorney asking the questions already knows the answers to half of them before you walk in the door. They pulled your county recorder's records. They ran your name through the Secretary of State. They know what you own. What they're trying to find out is how easy it's going to be to take it from you. By the end of this video, you'll know exactly what that examination looks like for a properly structured California investor versus someone who did the basic and stopped. What the creditor finds at each step, where they hit a wall, and what a 4-layer California structure has to include for any of it to hold. Here's what the creditor's attorney does before you're ever in the room. The first thing they do is to search the county recorder's database. It's public, it's free. They type your name into every county where they think you might own a property. For most California investors, what comes back is their full legal name, the property address, and the assessed value. The attorney has your asset picture in 30 minutes or less. That picture is what they use to decide whether full litigation or early settlement makes more economic sense. Many times, what can be used to solve this issue is using a land trust. When a property is held in a land trust, the recorded deed shows the name of the trust and name of the trustee and not the property owner's name. You just got to make sure the trust is drafted correctly and you did not name yourself as the trustee of the trust. Now, if the attorney searches the county, nothing comes back under your name. Does a determined creditor eventually find you through deeper research? Yeah, sometimes that happens. But the goal of asset protection is not invisibility, it is friction. When finding your assets takes longer and costs more than the expected recovery justifies, the decision to pursue changes. But privacy does not stop a lawsuit. Once a creditor files and wins a judgment, they move past the county records and they'll start looking at your entities. This is where the California LLC comes in. Every California investment property needs its own LLC formed in California, preferably one property inside of one entity. The liability from a claim against one property cannot spill into another LLC or another property if the properties are separated. And if the property is in California, then the LLC, that initial LLC, needs to be in California as well. Not a Wyoming LLC, not a Nevada LLC. I hear from investors all the time who formed out-of-state LLCs thinking they did get better asset protection on real estate in California. They didn't. They still owed California franchise tax. They still had to register their LLC as a foreign entity in California, still end up in California courts. No protective benefit, just extra cost. For California property, use a California LLC. Here's where the examination gets revealing for a lot of investors. The creditor's attorney asks, who owns the LLC? If the answer is you personally or your revocable trust, which is legally the same thing in the creditor's hand, they have found the asset. And here's the problem most California investors don't know about until it's tested. Under Corporation Code Section 17705.03, when you have a single-member California LLC, courts are not limited to a charging order. They can foreclose the membership interest. They can appoint a receiver. They can pursue remedies far beyond what a standard charging order allows. The charging order, which most investors think of as the protective wall, has statutory exceptions that swallow it entirely for a single-member LLCs. A single-member California LLC held in your own name is not a barrier. It is most of the time just a speed bump. So you cannot hold your properties personally because the asset search finds you immediately. You cannot rely on a single-member California LLC in your own name because Corporation Code Section 17705.03 removes the protection you thought you had. And you cannot use your revocable trust because a creditor can reach right through it. So what actually works? A Wyoming holding company sits above the California LLC. You own the Wyoming entity, not the California LLC that directly owns the property. When the creditor asks who owns the California operating entity, the answer points to the Wyoming LLC governed by Wyoming law, and Wyoming is where the charging order protection is real. Under Wyoming statute, the charging order is the exclusive remedy against an LLC membership interest, including a single-member LLC. The creditor cannot foreclose, creditor cannot appoint receiver, creditor cannot compel distributions. They can file for a charging order and sit there waiting for distributions that the manager may at some point make. That is leverage, not recovery. And that changes what they are willing to do at the settlement table. Now that the entity structure closes off the most obvious paths, let's show you the layers that actually removes the assets from your state entirely. LLCs create separation between you and your properties. They change how you hold an asset. What they don't do is change the fact that you still own the membership interest. That interest remains in your personal estate. Even with a Wyoming holding company above the California LLC, the Wyoming membership interest is still yours, held in your revocable trust, reachable by a creditor who gets to the membership interest level. The revocable trust provides no creditor protection at that layer. So to remove the ownership itself, you need an asset protection trust. Under Probate Code Section 15304, a California third-party irrevocable trust, where the grantor is not named as a beneficiary at all, gives you creditor protection that a self-settled trust in any state cannot match on timing. In Nevada, South Dakota, and Delaware, even their domestic asset protection trust statute requires a waiting period before the protection fully applies against future creditors. A properly structured California third-party irrevocable trust has no such a waiting period. If there are no existing claims, no pending lawsuits, and no creditors in the picture at the time of the transfer, the protection is immediate. That is a meaningful advantage over the self-settled DAPT approach. The important qualifier is this: immediate protection does not mean retroactive protection. If a creditor relationship already exists, meaning a claim has already arisen, even if no lawsuit has been filed yet, the Uniform Voidable Transaction Act can still reach back and challenge the transfer. The timing of when you build the structure relative to when any threat appears is the most critical variable in this entire analysis. The third-party irrevocable trust is not a last-minute fix. It is a foundation you build before you need it. And the rule on beneficiary status has no exceptions. The grantor, that is you, cannot be the beneficiary. California has no domestic self-settled asset protection trust statute, so if you name yourself as a beneficiary of your own irrevocable trust in California, the Probate Code Section 15304 protection disappears entirely. The creditor reaches right through it. The question that comes up immediately now is that if I cannot be a beneficiary of my own irrevocable asset protection trust, how do I access my income? And the answer to that is we can structure it in different ways if you need access to income that you could get income. And you may be asking, well, how do you structure it? So you can transfer a fraction of the Wyoming LLC membership interest into the irrevocable trust, not the entire interest. You can split the membership interest to voting interest and non-voting interest. That is exactly the same as a limited partnership. You have a limited partner, and then you have the general partner who has the right to vote and take care of everything. The voting interest usually goes into the irrevocable trust. That's where the creditor protection lives, and a creditor will have a very hard time reaching that portion of it. The non-voting interest, which doesn't provide a whole lot of interest to the creditor, they cannot manage the LLC, they cannot fire anybody, it's not an interest that could give them a lot of power over the LLC, goes into the revocable trust. You have direct access to the distribution that flows through that portion of the non-voting interest. And as I mentioned, you're not the beneficiary of the irrevocable trust, so that section of the probate code that would sort of dismantle the irrevocable trust protection protection if you're the beneficiary goes away. And the moment the irrevocable trust and the revocable trust are becoming members of the Wyoming LLC, now you have an entity that has two members. That matters because Wyoming's charging order exclusivity is even more clearly applicable and harder to challenge with multi-members. The Wyoming structure gets stronger at exactly the same time the trust layer is being added. One specific limit: keep the irrevocable trust allocation at or below 50%. California property tax law provides that if more than 50% of ownership in an entity changes, in most cases, it can trigger a reassessment of the underlying property. For a property held for years under Proposition 13, that reassessment can be catastrophic. You could go from your old locked tax base to a current market value in a single event. And we don't want that to happen. So the 50% cap is where the protection is worth more than what it costs. Now step back into the examination room. I'm talking about the debtor examination room with a properly structured investor. The county recorder search comes back with a land trust, not to the investor's name. The LLC search shows a Wyoming holding company. The charging order analysis runs into the Wyoming's exclusive remedy statute. The trust examination hits an irrevocable trust where the investor is not a beneficiary. At each step, the recoverable asset recedes. The cost of pursuit goes up. The certainty of outcome goes down. That's what the structure is designed to do. And that is what the structure is designed to do. Here's the diagnostic I give every client before we build everything. Run the creditor search on yourself right now. Go to the county recorders for every county where you own a property, type your name, see what comes back up. Go to the California Secretary of State and pull up your LLCs, see who owns them. If the search path leads back to you personally or to your revocable trust in your name, a creditor's attorney following the same path would find the same thing. That gap is worth knowing about before someone else finds it for you. The domestic structure I just walked you through is strong. For a lot of investors, it is exactly what they need and nothing more, but it has a ceiling. And there are 3 specific scenarios where a creditor can walk right through everything we just built. In the next video, I will show you exactly where that ceiling is and how to know whether you're someone who actually needs to go beyond it. I look forward to seeing you over